Recently, the government has brought in 130th Constitutional Amendment Bill, popularly described as Criminal Netas Bill. What is the essence of this bill? This bill says Prime Minister, Chief Minister, Union Ministers, State Ministers, if arrested for 30 days, in any case where the punishment will be for more than 5 years, will be removed from that post. Suppose if a sitting chief minister is arrested under a case where the punishment will be up to will be more than 5 years, and if he is in jail for 30 days, he will lose the job. So this is the essence of the bill. On the face of it, it looks like a bill to ensure probity and purity in public life, a bill to wipe out corruption in public life. Of course, the ruling party is trying to portray this kind of an impression. But is it a real big attempt to fight corruption or to fight opposition? Well, corruption is a serious menace in India which needs to be removed. There is no second thought on that. But is this the real way to deal with the corrupt politicians? So the argument of this bill is, well, we have seen Arvind Kejriwal. He refused to resign. He was the chief minister even while sitting in jail. And when he was released on bail, the court has kept conditions like he should not go to the chief minister's office, he should not sign on the files. So the argument in favor of this bill is such a situation where a minister, chief minister, if in case prime minister sits in jail, it will derail the governance. It will erode the people's confidence in democratic governance. So therefore, to ensure that the good governance, such criminal netas should be removed. Whence, if they are in jail for more than 30 days. Well, but what is the problem in this bill? The problem in this bill is, number one, it in fact violates the basic principles of criminal jurisprudence. The basic principle of criminal jurisprudence says, unless proven guilty, one is innocent. It is called presumption of innocence. The criminal jurisprudence doesn't presume guilty. It only presumes innocence. Anybody who is accused is not considered as guilty. He is considered as innocent unless proven guilty. So this bill violates that basic principle of criminal jurisprudence called the presumption of innocence. Because you will remove the chief minister, you will remove the prime minister, you will remove the ministers, not based on conviction. Well, if he or she is convicted, I am sure everybody will agree that the person has no right to stay in office. But this is not a conviction. This is not even a stage of charge sheet also. Just if the person is arrested, and in a case where the punishment can extend more than 5 years, and if he is in jail for 30 days, he loses his job. Well, the problem here is, so you are punishing a person even if the case is not proved, even if the charges are not proved. You are punishing a person without any trial, without any judicial oversight. How can you punish a person if nothing is proved against the person? In case if tomorrow it is established that the case is filed due to political vendetta, if the case is filed with a malicious intent, what is the compensation? The proposed bill laws doesn't say anything. So the argument of the BJP is that, well, the same party will remain in power, he can always come back. But that's not true with the politics every time. So if a person is removed, assuming that Siddaramaiah is removed, and because if he is in jail for 30 days on some case, will D.K. Shivakumar is made the chief minister for that particular period? What will happen if you ask Shivakumar to step down and give way to Siddaramaiah? What kind of situation you can always imagine. So it is in the present kind of politics, there is no guarantee that the chief minister will come back. And you have parties like BJP which try to create trouble. We have seen in Jharkhand, when Hemant Soren resigned, Arvind Kejriwal did not resign, but Hemant Soren resigned. So Champai Soren, a very big loyalist of the party and the Shibu Soren family, was made the chief minister on a temporary basis. But what happened? Champai Soren was not keen on leaving the office, subsequent to Hemant Soren coming out. So finally Champai Soren left the party and joined the BJP. BJP tried hard to destabilize Hemant Soren government using Champai Soren. Well, everybody will not be like, Paneer Selvan, who remains in office as long as Jayalalitha is in jail, and very loyally hands over the reins of power to his madam Jayalalitha. So the problem here is, technically, yes, a person can come back, but practically it will lead to a lot of political unrest and political upheaval and political machination by the rival parties. Then the question comes is, well, the argument now is, cases are dragged for years together, there is inordinate delay. As a result, many criminals are enjoying the offices of ministers, chief ministers, etc., etc. It is true. But the solution, the cure cannot be worse than the disease. Well, the solution is to expedite the trial process, to ensure that the judgments are delivered in time. So the speedy disbursal of cases is the solution for that. Today, what is the record of Enforcement Directorate? Everybody knows how the BJP-led union government is using CBI and ED to target opposition politicians. Even Supreme Court described CBI as a caged parrot. So what will happen if the government of India wants to remove an opposition CM? The easy thing is to file a case by CBI or ED under PMLA or UAPA. These laws are very, very strict laws. Under section 45 of PMLA, it is extremely difficult to get even a bail, because there are two conditions. Condition one is the public prosecutor will have a right to oppose it. Then there is a condition two. The judge should come to a prima facie understanding, should come to an understanding that this case, that there is no case, there is prima facie. So no judge will take that risk. So that is the reason in a PMLA cases, it is extremely difficult to get a bail. So we are seeing how PMLA is being misused, how Unlawful Activity Prevention Act, UAPA, is being misused even against ordinary journalists. So what will happen if the government of India, if the ruling dispensation center just wants to remove an opposition chief minister? They can simply ask CBI or ED to file a case under PMLA or under UAPA. The CM will be arrested and he will be sent to jail, and minimum 30 days he will be in jail. So therefore he loses his job. So what is the conviction rate? When over 5,000 cases are filed, the conviction has taken place only in 38 cases. Majority of the cases do not even reach the trial stage. Forget about the logical end. So the conviction rate is abysmally low in all the cases filed by the Enforcement Directorate. So therefore, even 95% of the cases filed on the prominent politicians belong to the opposition parties. Everybody knows this. If any tainted leader wants to bypass the problem of litigation, the problem of case against him, he can simply join the BJP. We have seen Ashok Chavan, the accused in the other society case, becoming a BJP MP and a chief campaigner for the party in Maharashtra. We have seen Hemant Biswa Sarma facing CBI cases while in Congress, but he joined the BJP to become the chief minister. We have seen Y.S. Jagannath Reddy, due to its proximity with BJP, could be on bail for more than 11 years. So we are seeing how the things are happening in the country today. So given this kind of a situation, the bill that empowers the executive to remove a chief minister, elected minister, selected chief minister, is absolutely uncalled for. It is against even separation of powers. How can an elected chief minister be removed without any judicial or parliamentary intervention? He is not losing majority in the House and no court has convicted him, still he is losing job. So that is absolutely uncalled for. It attacks the very principle of separation of powers and it becomes an unconstitutional law. So I am not sure whether this will stand the scrutiny of a judiciary, because it is absolutely against the very principles of the Constitution. Well, the ruling BJP says even Prime Minister, it applies to Prime Minister. But everybody knows the CBI and ED work under Prime Minister. Can they file a case on Prime Minister, that too serious cases where the punishment is over 5 years? Can you expect CBI, ED to arrest the Prime Minister who is actually their boss? So let us understand, this bill is not to eliminate corruption. It is essentially to trample upon the federal character of the Indian Constitution and simply create trouble for opposition parties. So it is an attempt to remove opposition politicians from power without the involvement of either people or the judicial process of conviction.